Good morning to everybody. So my name is Andrew Davidson. I'm the National Head of Employment at Hempsons, and this is one of several webinars we're doing nationally this year on a range of topics. And most of the topics we've chosen, in fact, all the topics we've chosen, are based on feedback from delegates in previous events. And so at the end, there is a form for feedback. We'd be grateful if you'd fill that in, but also to provide any suggestions for future webinars so that we are providing you what you want. That's the whole point of these things. So this morning I'm going to talk about preventing and addressing sexual harassment, some of the legal considerations, practical considerations, and I'm going to cover that in a few parts. First of all, a tiny bit of background, just a little bit to frame the session. Then the majority is going to be looking at the legal framework, the current legal framework, the changes, the way the law works as it currently stands and the way it's going to change. Then some practical steps, things that employers should be doing, looking at doing in order to prevent sexual harassment, deal with sexual harassment. And then at the end, time for questions and answers. This session will run for about an hour. We might run slightly over, but thereabouts. And so if you have any questions, by all means, either put them in the chat or save them up for the end. So just by way of background then, some interesting figures, some interesting statistics. I think most of us are aware of the cultural shift that's happened in certainly the last few years with the Me Too movement and other developments. And there've been some interesting statistics, particularly in relation to the UK position. TUC report in 2023, which did a poll of, I can't remember the exact numbers, about 1,000 people, I think it was. And the interesting figures that come out of that poll and that survey are presented on the slide. So 3 in 5 people reported sexual harassment, bullying or verbal abuse in the workplace. 62% of women aged 25 to 34 experienced it. And in 2 out of 5 recent incidents, the perpetrator was a third party rather than another employee. And I'm going to come back to the position on employer responsibility for third party harassment later on in this talk. Another interesting figure was that less than 1 in 3 women who suffered sexual harassment told their employer about it. And one of the things that I'm going to address in the practical steps is the way in which you can change the culture, the way in which you can have reporting mechanisms to enable more people to come forward if they're in this position. And then because a lot of people on this webinar are from the NHS, I thought I'd provide some very NHS specific findings. The NHS Staff Survey 2023, the new version has just come out, of course, but 2023, 80,000 plus reports of sexual harassment amongst NHS staff. 8.67% of staff experiencing harassment from patients or the public, 3.84% from colleagues. Some elements within the NHS more likely to have higher rates of sexual harassment, ambulance staff, mental health services staff reporting that. So some interesting findings, and you can find more interesting findings in the latest version of the staff survey, but that's where we were before. Unison also have done their own survey in 2024, very large survey numbers, 12,200 health workers revealed that was the survey. 1 in 10 experienced unwanted incidents, 29% reporting sexual assault. 1 in 4 had been harassed, said they'd suffered unwelcome sexual advances, propositions or demands for sexual favours. And the most common issue, again, I suppose instinctively we probably would realise this, but the most common issue was crude banter or jokes, with 3 in 5 workers experiencing some form of harassment. Again, a similar theme about people not being feeling able to report harassment due to fears of being seen as oversensitive or thinking that complaints wouldn't be acted upon. So some general themes coming out of the statistics. I think lots of people have their own experiences and reports from colleagues and so on, but clearly it is an issue, a serious issue in the workplace, and one that needs to be addressed by employers. So that's really just some context. Now I'm going to look at the law and how the current provisions work. So if you look at section 26 of the Equality Act, in essence, there are 3 different types of harassment, and to an extent there is crossover. So individual employees who bring claims might bring claims under several of these headings, but broadly there are 3 different types. First of all, harassment generally, so that's related to any protected characteristic. That could be sex, that could be age, it could be any other protected characteristic, but that's harassment generally. And that could relate to sex. So employment lawyers tend to talk about that as being sex harassment rather than sexual harassment, because sexual harassment is a different context, and I'll come back to what the definition of sexual harassment is, but that's the second type of harassment. And then thirdly, less favourable treatment because the employee has either rejected or indeed submitted to unwanted conduct of a sexual nature, or that's related to gender reassignment or sex. So 3 separate headings for types of harassment. As I say, there is some crossover. The protection under the Equality Act protects a wide group of people, includes job applicants, employees, and workers. Just a reminder that workers is this slightly broader category. It includes employees, but it's broader. So anybody that's providing personal services is likely to be considered to be a worker for these purposes. So broad protection under the Equality Act against these 3 different types of harassment. So then just going back to the second type, which is sexual harassment. What is sexual harassment? Sexual harassment occurs where person A engages in unwanted conduct of a sexual nature, and that's the key part. And the conduct has either the purpose or the effect of violating that other person's dignity, or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. I'm going to look at each of those elements in turn, but so just some general points first. A person, this is coming directly from the Equalities and Human Rights Commission guidance. A person can be sexually harassed, of course, by someone of the same or a different sex. Doesn't matter whether the person who's doing the harassing intended to create that type of environment. As I say, it could be that it has the effect, and I'll come back to that in a moment, but it could be the effect of their conduct. It doesn't have to be intentional. If you want to look into this further in terms of the technical guidance, it's well worth having a look at because it's online, it's free, and it's not complicated, and it's a worthwhile read. It's worth having a look at the Equalities and Human Rights Commission Code. This is described as a technical code, but don't let that put you off. It's not actually that technical, but it does look in more detail at what sexual harassment means for these purposes. So the first issue then is, what does unwanted mean? And the code says, as you might expect, again, it's not particularly complicated. It's the same essentially as unwelcome or uninvited conduct. That's what unwanted means. Does not mean that you need to have objected before the conduct to deem it to be unwanted. It can be something which you have not expressly objected to, of course. It can be, by its very nature, unwelcome or uninvited. And include any unwanted verbal, non-verbal, or physical conduct of a sexual nature. And it always has to come back, in order to fit within this heading, it always has to come back to whether the conduct is of a sexual nature. The code itself says that a serious one-off incident can amount to harassment. And indeed, there's an old case now going back to 1999, Reed against Stedman, where the Employment Appeal Tribunal said that a series of relatively minor, in the grand scheme of things, relatively minor incidents could, when taken together, taken cumulatively, could amount to harassment. And certainly a serious one-off incident can amount to harassment as well, and that's clear from the code. As I mentioned before, it's not necessary for the person who has suffered the conduct to have already made it clear that somebody's conduct is unwanted. And again, an old case, in situ cleaning against Heads, 1995, the Employment Appeal Tribunal considered an argument that the man concerned, who'd made an offensive comment about one of his co-workers, the Employment Appeal Tribunal considered the argument that the man couldn't know that his conduct was unwanted until he'd been rejected. And they rejected that argument. They said, you can't test the water. You can't test the water if the conduct was serious enough to be reasonably considered harassment. So this concept of unwanted doesn't mean that you have to have expressly said, I don't want you to do these things. There are certain types of behavior, because they are sexually related that are on the face of it, without any previous discussion, are harassment because of the nature of the conversation or the physical action or whatever it happens to be. Similarly, in cases where sexual conduct has been welcomed or at least not unwelcome in the past, it can become unwanted. And we see this in regular pieces of advice that we're asked for, where either a relationship has happened and then it's broken up and there's problems after that, or where individuals have willingly and without any problems engaged in sexual conduct and then made the decision that it's no longer welcome. And the point about that from the technical guidance is that that can still amount to harassment, even though it may have been welcomed in the past, because the individuals changed their mind, and rightly, that then becomes unwanted. The code gives all sorts of examples. I think most of us could probably come up with these examples, but it gives examples of the sorts of things which could be considered conduct of a sexual nature. So some of the obvious things, displaying sexually graphic pictures, posters or photos, suggestive looks, staring or leering, propositions and sexual advances, all that kind of thing that you would expect. Equally, sexual posts or contact on social media, spreading sexual rumors, and so on. So a whole variety of things that, in theory at least, can amount to harassment because they are conduct of a sexual nature. A case from 2004 makes the point, which is good law, that the conduct itself, if it's of a sexual nature, doesn't have to be directed at the employee themselves. So this case of Moonsar against Five Ways Express Transport Limited was a case where there was a data entry clerk, female data entry clerk, working evening shifts. She became aware of male colleagues who were downloading porn onto their own work computers. She hadn't seen the images and she hadn't complained at the time, and so the actions were not directed at her, but the Employment Appeal Tribunal accepted that this was treatment and conduct which could undermine, or would undermine in this case, the claimant's dignity. So it doesn't have to be directed at the individual. If people are engaging, for example, in sexual banter, and somebody takes offence at that and thinks it's unwanted, even if it's not directed at them, they can still bring a claim for sexual harassment under these provisions. Just going back to the point I was making about purpose and effect, if in any given case the unwanted conduct of a sexual nature is deliberate and purposeful, so if the individual is purposefully violating the individual's dignity or creating a certain type of environment, that's enough. And so the individual's perception's irrelevant, any other factors are irrelevant if it's deliberate. And so if that's the purpose, and that's the way the tribunal conclude that it happened, if it's purposeful, then sexual harassment is made out. If it's not purposeful, so if it's not clear that it's the intention of the individual, then a tribunal would have to consider the effect of the conduct on the other person. And in reaching that view, they must consider a number of things. They must look at the individual's subjective perception, how they perceive that conduct. They have to look at the relevant circumstances of the case. So, for example, if the harasser is in a more senior position, that can have an impact on whether or not sexual harassment is made out. And then finally, there is an element of objectivity, because a tribunal will have to ask itself whether it's reasonable in all the circumstances for this particular conduct to have the effect it has on an individual. So a number of elements will go into consideration in a tribunal case about whether or not harassment is made out. But certainly it is relevant what the individual's perception is, but equally it has to be reasonable in the eyes of the tribunal in all the circumstances. So there is a degree of objectivity to the assessment. So if you remember at the beginning, I said there are three different types of harassment. The first type is harassment on the grounds of a protected characteristic. Second is sexual harassment, which we've just talked about. And then the third, which is really more a subcategory, I think, of sexual harassment generally, is the less favourable treatment for rejecting or submitting to conduct. And the example given from the code is a shopkeeper propositions a shop assistant. She rejects his advances and is then turned down for a promotion. So pretty straightforward in concept. You're treated less favourably because you've rejected or submitted to sexual conduct. So now let's look at the recent changes in this area. Some interesting things that came into force on the 26th of October 2024. There is now a positive duty on employers to take reasonable steps to prevent sexual harassment. So the way that the provisions are under the Worker Protection Amendment of the Equality Act 2010 Act 2023, which is a bit of a tongue twister, the way that it's phrased is an employer must take reasonable steps to prevent sexual harassment of employees of A in the course of their employment. What does reasonable steps mean? Well, there are a number of factors that will go into consideration of what's reasonable. Some of those obvious, some of them less obvious. So the specific circumstances of the employer, including its size, the sector in which it operates, the grievance and reporting procedures it has in place for dealing with sexual harassment in the workplace, and so on. But there's a whole variety of steps, and I'm going to come back to that when I look at the practical steps that I suggest employers take in a moment. The requirement at the moment, so from the 26th of October, is to take reasonable steps. The government is committed to changing that and making it more strict so that it would be all reasonable steps. We don't have a deadline for when that's going to happen. We don't have an idea, but it will be coming probably this year, maybe next year, but certainly fairly short term. There will be a change so that it will be a requirement to take all reasonable steps. Now, you might ask what the difference is, and until we see the guidance on the regulations, it's not entirely clear, but it seems to me that it must mean at the moment you could take a variety of steps and still fulfill the duty, because you can say we've taken reasonable steps. Under the obligation to take all reasonable steps when it's introduced, that clearly will be more onerous. And it seems to me that the way that will work is all it will take is the employee rather, or the tribunal to conclude that there were other steps that could be taken, and you've probably fallen foul of this duty if they're reasonable. So it's likely to be more stringent. We don't know exactly how that's going to work. The Equalities and Human Rights Commission will enforce this right, so they have the ability to enforce where they think an employer has not taken reasonable steps to prevent sexual harassment. And if an employee, because they can't bring a separate claim for this, but if they're bringing a sexual harassment claim in the tribunal anyway, if there has been a breach of this positive duty, tribunals can award an uplift to any employee's compensation of up to 25%. So just to be clear, you can't as an employee bring a claim purely on this basis that the employer hasn't taken reasonable steps. The Equalities and Human Rights Commission can enforce it, but you can't as an individual, but you can certainly join it in to any claim you have already for sexual harassment in a tribunal. As I said before, I would have a look at the technical guidance because it's worth looking at, and I'm going to look at the 8-step guide, which is produced by the Equalities and Human Rights Commission in a lot more detail shortly. But a few things to note. The guide says it's anticipatory for employers. So you shouldn't wait for incidences of sexual harassment to happen before taking action. You should anticipate scenarios in which employees might be subject to sexual harassment and then take reasonable steps to prevent it. Examples in the code of the sorts of things that you could do as an employer: have a clear and well communicated anti-harassment policy, make sure that staff are trained, and have an anonymous reporting mechanism. Now, I said I'd come back to third parties, and I'm going to come back to third parties again a bit later on. But the guide, just while we're here on this point, the guide is very clear, technical guidance is very clear, that the Equalities and Human Rights Commission will enforce the duty in relation to third parties. And so if you have not taken reasonable steps as an employer and an individual suffers harassment, sexual harassment from a third party, which could be a patient, could be a supplier, could be an agency staff member, then the Equalities and Human Rights Commission will take enforcement action, or will consider taking enforcement action in those circumstances. Now, there is a slight tension because, as I'll come on to explain in a moment, the existing law on obligations on employers and how it fits with third-party rights are not quite the same as what the guidance says, but that's going to change in any event. So I'll come back to that point in a bit more detail shortly. So have a look at the 8-step guide. It's my recommendation. There are, as you wouldn't be surprised to learn, 8 steps. And I'm going to look at some of them, not all of them, but I'm going to look at some of those in thinking about what employers can do to prevent sexual harassment and to comply with the responsibilities and the duties. So the first step is developing an effective anti-harassment policy. Sorts of things that you might want to include, and this is just guidance, this is not something that you're required to do, but some things that you might want to consider. Confirm who's covered by the policy. Does it cover all staff? Does it cover agency staff? Does it cover bank staff? Does it cover other people? So be clear who the policy applies to. Make it very clear, obvious, but make it very clear that sexual harassment is unlawful and won't be tolerated. Some organisations have what they describe as a zero tolerance approach to sexual harassment. The Fawcett Society recommends that. That's up to you as an organisation, but certainly it would set the scene for the way in which you as an employer would deal with these sorts of situations. It's also useful to set out the definition. I would be minded to set out the legal definition of sexual harassment so people are clear on what that means. Make it very clear that there will be disciplinary consequences up to dismissal if somebody has committed sexual harassment at work, in situations related to work, so a social event, for example, against a work colleague or another person connected to that work, including on social media, and against anyone outside of work situation where it's relevant to the role. So if they have a particular role and this happens outside of work, this might also be relevant for the purposes of a disciplinary case. Useful to make the point that abuse of power could be an aggravating factor. We often see that it's more senior employees who sexually harass more junior staff, not always, but it does happen more often than not. And so abuse of power could be an aggravating factor. And set out very clearly reporting mechanisms so that employees know where they can go to report these incidents if they happen. And on that point, engagement with staff is really important, making sure that the policy is freely available and easily available to everyone, giving thought that not everybody has easy access to email, for example, or your intranet, or however you put your policy. There might be other ways of getting it out to staff, so think about that. Think about how you make it clear to people that there are consequences of breaching the policy. And as I say, and I'll say repeatedly because it's an important point, how they can report incidences either on an anonymous basis, which some people would suggest, or anonymous and named, depending upon how your systems are set up. And then consider how you publish that, as I say, and remind people. So if you have an intranet, if you have newsletters, staff meetings, all that kind of thing, certainly for induction purposes. And the other thing that's recommended by some of the guidance is reminding staff ahead of big social events like Christmas parties, and perhaps sending an annual reminder to staff that this policy is in place and the sort of expectation of behaviour that you have as an employer. One of the key things, particularly now that the new duty is in place, is to assess and to look at risks across the organisation. And the Equalities and Human Rights Commission have gone as far as to say that you're very unlikely to be able to comply with the positive duty unless you've undertaken a risk assessment. What does that involve? Well, mainly anticipating scenarios where sexual harassment is more likely to happen, or where there's at least a risk of it happening. Think about some of the risk factors. There's a whole list of risk factors there. I'm not going to go through all of them, but some of them are obvious, some of them less obvious, particularly where there are power imbalances, for example. Certain types of working. So again, the guidance talks about lone working, where the individual might be isolated, night working, any out of hours working, any event where there might be alcohol, for example, that can cause difficulties, particular local or national events which raise tensions, which again might make individuals more likely to take part in this kind of conduct. Other factors, again, I'm listing them here, but just looking down them, social media is one of those things that we often get questions about. Culture that allows banter. A lot of clients will tell me that there aren't instances in their workplace really where banter happens and it's not tolerated. I think for the most part that's probably not right. I think there will be pockets of certain types of teams, for example, where there is a sort of banter that's allowed to grow up, and it can cause all sorts of problems for you in relation to sexual harassment and preventative steps. Sometimes it may be that there are particular individuals, and the risk really only relates to a very small number of individuals, but nevertheless, you should still do the risk assessment and see whether you can minimize that risk. The research shows that workers with more than one protected characteristic are more at risk. And so, again, give some thought when it comes to risk assessments to whether there are categories of staff that are particularly vulnerable and what you're going to do to minimize the risk to those staff. And in each case where you have a risk, there is an expectation that you create an action plan to deal with that risk and to have steps in place to show that you're complying with the reasonable steps. I mentioned reporting earlier. I think there are a number of elements to that. One is encouraging a positive reporting culture. It's similar to, in the NHS in particular, encouraging a freedom to speak up type culture, the ability to individuals to raise these issues. That's the sort of culture that you want for all employers, that people feel able to do that in a positive way. Making sure that there are different ways to report concerns. Anonymous reporting is an option for sure, and it's recommended as part of the guidance. And so if individuals are not understandably not prepared to give their details, they can still nevertheless find a way to get the information to the employer, which is valuable. One of the difficulties that employers face with anonymous complaints, of course, is it's very difficult, if not impossible, to investigate them, because if you truly don't know who the individual is and they haven't given you those sorts of details, it's very difficult to do anything by way of an investigation. But what it can do is it can highlight A, the level of unease within an organization, and B, it can put on your radar that there might be teams, there might be areas where you need to consider again whether there's a higher risk and whether there's other things that you need to do. The guidance says you shouldn't set a time limit for reports. Most of you will have grievance policies, for example, that do have a at least indicative timescale for which you need to comply to put your complaints in. It's very clear that the guidance says you shouldn't time limit it. So if people feel able to come forward a considerable time after the incident, that shouldn't be a reason not to take it forward. And then just in terms of the channels, recommendation, telephone helplines, online portals, there may be other ways of doing it. But the key thing is you've got an effective reporting mechanism. We're also getting asked a lot at the moment about training, and this will be an essential plank for any employer who is going to turn around and say we've taken reasonable steps. And that should be, of course, anti-harassment training. Certainly recommended for managers, but also for all staff, so that people understand what sexual harassment is and how they can deal with it, either if they've experienced it or if they are managing people that have come to them with these reports. So training, absolutely critical. Most organizations would be encouraged to have it as part of your induction, making sure that your training is tailored. It may be, for example, that you have a different form of training for higher risk areas. Maybe that you want to tailor it slightly further depending upon the nature of the organization. But either way, you have in place effective training. And then this is a kind of lawyer's point, but it's an important point. Make sure that once you have got those effective ways of training in place, you keep accurate records, because if at some point you are called upon to defend yourself and to say, these are the steps that we have taken, you have an accurate record of people who've undertaken the training, who understand. It also helps you when it comes to potentially taking disciplinary action. So if you are taking disciplinary action against somebody who's guilty of sexual harassment, then the fact that they may have been through training, they've been educated, they understand the issues, but nevertheless, they've done that, that can be a relevant factor when it comes to considering sanction at the very least. I said I'd come back to third-party harassment because this is something that's going to change in the next few years. The government have made it very clear that they are committed to reintroducing employer liability for third-party harassment, because it went after a number of cases, and then finally it was repealed. The provisions that were in the Equality Act before were repealed. But this is where we are at the moment. So as I said, it's a little bit of repetition, but I think it's worth bearing this in mind. So the Equalities and Human Rights Commission have said very clearly that they think the preventative duty rather, extends to her sexual harassment by third parties, and they intend to enforce it. So that's very clear. So as an employer, it would be wrong for you to think that third party harassment will be without consequences. And so you need to consider the risk that your employees might face from sexual harassment from third parties. But the legal position at the moment is different. So at the moment, until the law changes, employees can't normally bring claims against their employer for the harassment they've suffered from third parties. And there are two notable cases. One is Unite the Union against Nailard, and where the Court of Appeal said, look, the employer is only liable in exceptional circumstances. And an employer you'd need to show, the employee would need to show that the reason the employer failed to take steps was in fact itself the protected characteristic. So that was the failure. And again, similar point in Besong against Pennine Care, which is one of our cases. The NHS Trust in this case was not liable for racial harassment because any failures to prevent were not because of race. The same applies to sexual harassment. It's exactly the same. So at the moment, it's not easy for employees to bring a claim unless they can show that the treatment they've suffered directly by their employer is in itself discriminatory. But as I say, that will change, and that does pose all sorts of challenges for your organisation, because inevitably you will have third parties over whom you have no significant control, potentially doing things which amount to sexual harassment, for which you might be liable unless you've taken reasonable steps. So just to finish off, I want to say a few things, because we have so many people from the NHS on this call. I want to say just a few things about the Sexual Safety Charter, because I know that a lot of trusts are currently working to implement this and are looking in great detail at sexual harassment generally. So I just want to say a few things. And I think the other point I'd make is that whilst the Sexual Safety Charter is an NHS specific creation, this is something that actually is very useful to all sectors, because the work that's gone in and the backup and the guidance and so on to support this is useful in any context, in any sector, for those people that are trying to prevent and put in place effective mechanisms to prevent sexual harassment. So this was very much a response to concerns about sexual harassment, abuse and assault in healthcare settings. The purpose is to create a safe, respectful and inclusive environment for everyone, to set very clear expectations and standards in relation to sexual safety. And this aligns very much to the NHS's commitment to patient care and staff wellbeing. And it's very much in line with the Equality Act provisions, as I've said, and the NHS Constitution. It's a little bit small for some of you who are looking at the slides, but you can look at this when you will get full copies of all these slides. You can have a look at this if you want to, but some of you will be very familiar with this. So again, as I said, not just for NHS people, but generally there are some very useful elements to the Charter. So obviously eradicating sexual harassment and abuse, promoting a culture rather, that's all about openness and transparency. It doesn't tolerate these kind of behaviours. It is difficult on the cultural side, isn't it? Because it really does take lots of things to change and shift the culture. As it has done and is still doing in relation to freedom to speak up, for example. But clearly a commitment to doing these things, to being more open and transparent, and then backing it up with action is the way to go. The point that I mentioned earlier is recognised in the Charter about an intersectional approach to sexual safety of the workforce, recognising that some people will fall into groups which experience more sexual harassment and abuse in a disproportionate way. Making sure there's enough support, again, very standard things that we need to look at, making sure that people understand what behaviour is acceptable and what isn't. Clear policies, and there is an NHS England policy, of course, which some of you have got in place or are changing your own policy to meet. Training, reporting mechanisms, all the things that I've talked about before. One thing that I haven't mentioned, and I do think this is an important aspect for everybody, is not just taking reports seriously, but also being seen to take reports seriously, and making sure that where these issues are raised, they are dealt with in an appropriate manner. I mean, certainly there's been a cultural shift over the years, and complaints of sexual harassment are without doubt, in my experience, now taken far more seriously. But it is something which is important, because those people, we go back to the statistics about people unwilling to come forward, and understandably so, because they're concerned about the impact. Having an organization that clearly takes these things seriously is going to make a difference over time and change the culture. And then finally, capturing and sharing data on prevalence and staff experience, being very transparent about that. Some organizations I know are nervous about publishing some of the data. I think the NHS generally is better because of the nature of all sorts of data that you have to report in relation to other protected characteristics as well. But certainly when it comes to a culture, you want a culture that is willing to have the difficult conversations and share the data on prevalence and staff experience. And then finally, again, all coming from the Sexual Safety Charter, but useful generally for employers, the sorts of things that you want. This is a reiteration of the things that I've been talking about, making sure that you've got good policies, making sure you've got training and awareness programs, making sure reporting mechanisms are in place, making sure that there are support systems for those affected, monitoring and evaluating any schemes, so making sure that the steps you've taken are effective by looking at the data, looking at the perceptions of people to see whether or not you're making the right change. And then finally, and this really is an important point, again, not just for the NHS, but more broadly, leadership and accountability, making sure that somebody is accountable for your record on sexual harassment, making sure that somebody is accountable for the steps you're going to take and to champion good behaviour in this regard. So that was all I wanted to say. We have plenty of time for questions and answers, and we anticipated that we might have quite a few this time round. Heather, I think we've got some in the chat already, is that right?
Hello, yes, Andrew, we do, and we also have somebody with their hand up. So if I may take the first question first. How do employers manage the conduct of sexualized conduct of residents with learning difficulties or brain impairment against their responsibilities to employees? How does this stack up against the human right of residents to expression of freedom and their dignity?
Really good question, and one that affects lots of organizations. And I think it goes to the heart of this difficult balance, doesn't it, between caring for people in the right way and accepting that some behaviour, whilst on the face of it is of course unacceptable and is unacceptable, comes from either their mental health conditions or for other reasons. You are in a difficult balance, because of course individuals have the right freedom of expression, but equally the employees concerned have the right not to be subjected to sexual harassment or in fact any other form of discrimination. What you will have to show, and this is not much of an answer, but what you will have to show is that you've taken reasonable steps to make sure that that balance tips the right way. And that's incredibly difficult, I think, and not least because, I mean, we've had cases where individuals have said rightly that they are experiencing the sort of conduct that's completely inappropriate against them because of individuals that they're caring for. The difficulty is sometimes if you offer to move the member of staff and you say, well, actually, we accept that it's not acceptable, but there's nothing we can do about it because of the nature of the individual patient or service user. The difficulty is if you move a member of staff on that basis, potentially that in itself is a detriment. And so, if the individual doesn't want to be moved for career development reasons or for other reasons or for, financial reasons or whatever, you're exposing them to a detriment. So you've got potential for a claim. So it's a very long way around saying there is no way to square that particular circle apart from making sure that you've got these steps in place and you respond. But if you have a responsibility to work with a service user or a patient and they have the difficulties you've mentioned, of course, that's going to materialize in that way. Not much of an answer, because there isn't much of an answer, but it's the best I can do.
Thank you, Andrew. Justine, you have your hand up. Would you like to unmute yourself and ask your question?
Thanks, Heather. Thanks, Andrew. I was just wondering about the criminality aspect of it. So at what point does workplace sexual harassment cross the line into criminal behaviour? how does that impact on employer obligations in a way?
Yeah, no, I mean, absolutely, and it can be a criminal offence. I've steered clear of all the potential for criminal offences, but it certainly can be, and it does cross over. I think the challenge sometimes that employers have is doing everything in a way that's sympathetic and understanding to the individual. And so we have had cases, for example, where the employer's been very keen to go to the police and say, we think this is potentially a criminal issue. But you are in a difficult position, aren't you, if the individual says, I don't want that to happen. And so everything you do, I think, has to be in concert with the individual who's come to you and in confidence and shared the issue with you. If they, let's assume that they are prepared, either they've gone to the police themselves or they're prepared for you to go and you to support them and to help them through that process, then in that sense, it's like any other ongoing criminal process. You know, it may be, for example, that your investigation that you're intending to take part in as an employer can't go ahead because there's a criminal element to it. So liaison with both the individual who's raised the concern, making sure they're content with your approach to the police, but also making sure the police are happy with what you're doing is critical in all of this. And you just don't want to take any action that's going to make life harder for the individual and is against their wishes. Your obligations to positively report are few and far between, frankly. So most of the time, this is something in this context for sexual harassment that is done in concert with the individual employee. But it might prevent you, at least to begin with, from undertaking an investigation.
Okay, thank you.
What else have we got, Heather?
Thank you, both of you, for that. Somebody is thanking us for raising the Freedom to Speak Up Guardians. As they're saying, we have an AAP in our organisation that colleagues can report confidentially and anonymously.
Yeah.
Somebody is asking, please, can you just go over the difference between sex harassment and sexual harassment again, please?
Yes, it's a tricky distinction, and it's one that very often people do struggle to understand. But the way to think about it is this: that for any protected characteristic, whether it's age, gender reassignment, race, whatever it happens to be, there's a general provision which deals with harassment, and that's in a situation where, because of the protected characteristic, you're subjecting an individual to the sort of environment I described, which is, you know, the humiliating and so on environment. Either you do that purposefully or you do it unintentionally, but it has the effect. So that relates to the protected characteristic. So that's sex harassment, where the reason, the fundamental reason is your sex. It's not sexual in nature. The conduct doesn't have to be sexual in nature, but it's because of your sex. So that's sex harassment. So an example would be where you are subjecting an individual to that kind of environment just because she's a woman, not because there's any sexual content to it, but you are subjecting them to a humiliating environment because of their sex. Sexual harassment has to have a sexual element to it. It has to be a sexual rather than a sex element to it. So that's the distinction between the two. There is some crossover for sure, but the primary distinction is whether or not it's sexual conduct or whether it's just inappropriate conduct in that way.
Another comment that's come in: it's important for staff to also understand that they can be directly liable, especially if going to an ET and the employer and individual are cited. They were required to make financial compensation directly.
Yes, good point. Individuals can be, in the same way that they can be for whistleblowing detriment, they can be liable for sexual harassment. Yeah, it's a good point.
Thank you. The next question is, can a worker use a diagnosis of neurodiversity to explain and excuse their sexual behaviour towards other staff members if a complaint is made against them?
Well, they can use it as an explanation, and so they can explain that they're behaved in this way because of whatever the condition is, whether it's whether it's a neurodiverse condition, whether it's any other form of impairment. But it's not an excuse, in the sense that if you're going through a process, if somebody's behaved inappropriately towards another member of staff, you will take them through a disciplinary process, and it might be mitigation. So it might be that when you come to make a decision, the fact that there is an explanation might be enough to say, well, actually, rather than dismiss, we're going to go for a final written warning. But one of the other issues, of course, is whether or not the behaviour is likely to reoccur, and that again can have an impact. So it's a relevant factor for sure, but it's not enough to say, well, actually, therefore, we're not going to take any action. All sorts of physical and mental impairments can cause or contribute towards certain types of behaviour, but nevertheless, the behaviour is still inappropriate. So you get to the cause, you understand what might be causing it for sure, but it's only mitigation. It's not necessarily an excuse that would mean you wouldn't take any action.
We have been considering rolling out risk assessments on a departmental level to ensure that we capture differences in risk between areas. Would this be a recommended approach, considering this may lead to numerous action plans, or would a wider organisational risk assessment be recommended instead, or as well as?
I think the answer is as well as. There's no question that if you have differences between teams, differences and risks between areas, there's no question that it makes sense to risk assess them and then have separate action plans for sure. But it may be on top of that, you have a broader, wider organizational risk assessment as well. So it's not an either or in my mind. I think if you can see that there are those risk areas, as I've said, having the right plan in place is going to be important to be able to say that you are taking those reasonable steps.
We've come to the end of our questions, but please do, as Andrew is putting up here, fill out our feedback form, because as he's mentioned at the beginning, this is very important to us when we are planning our webinars, and we're looking at the series of employment webinars coming up later in the year. So we would very much welcome your input on this. If after the webinar you've had a chance to sort of mull things over and you have questions at the end, Andrew's contact details are on the slides as well. So please do get in touch. So it just remains for me to say thank you to you all for attending this morning, and to Andrew for leading us through this prevention of sexual harassment webinar. And we look forward to seeing you at our next employment webinar later on in the year. Thank you.
Thank you, everybody.
Thanks, Andrew.